Good morning, everyone, and welcome to the third meeting of the Interim Joint Committee on the Judiciary. Call this meeting to order, and would our clerk please call the roll?
Senator Berg. Present. Senator Carroll. Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm. Senator Turner. Here. Senator Wheeler. Here. Representative Banta. Here. Representative Blanton. Here. Representative Bratcher.
Here.
Representative Bray. Representative Burke.
Here.
Representative Decker.
Present.
Representative Dietz. Representative Flannery.
Here.
Representative Herron. Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosier.
Here.
Representative Nemes.
Here.
Representative Petrie.
Here.
Representative Rawlings.
Here.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson. Co-Chair Westerfield. Co-Chair Elliott.
I'm here. And so the first item is to consider the minutes from the second meeting. Is there a motion to approve the minutes? Motion. There's a motion. Is there a second? There is a second. All those in favor, please say aye. Those opposed, no, and the minutes are approved. Our first item, so we're going to go out of order a little bit on the agenda, is immunity from criminal liability for healthcare providers. House Bill 252, Representative Jason Nemes. Sir, you're already at the table, so if you would introduce yourself for the record, and then I know you have a guest on Zoom.
Thank you, Mr. Chairman.
As well, and you can proceed. Thank you.
I'm Jason Nemes, and thank you for calling us first. My friend, I see Miss Hester is on here. She's stepping out of the operating room to testify. Let her identify herself for the record, and then we'll be quick in our explanation.
I'm April Hester, a certified registered nurse anesthetist representing the Kentucky Nurses Association today.
Thank you, Mr. Chairman. So this is, as you can see, a four subsection, less than one page bill. What it does is it says that if a healthcare provider is doing their duty, providing healthcare services to our people, then they won't be criminally liable unless they've engaged in, and this is subsection 3, gross negligence or wanton, willful, malicious, or intentional misconduct. So it protects them from having to answer in a criminal court of anything that they might do, have any mistakes that they might have made. Want to mention very quickly that this does not have anything to do with civil liability. So that's the nutshell. I think Ms. Hester has a few words to say, and then we'll answer any questions.
Ladies and gentlemen of the committee, I would like to thank you for your time and attention today. As previously stated, I'm April Hester, a nurse anesthetist representing the Kentucky Nurses Association. I'm very sorry I couldn't be there with you guys today in person. Like Representative Nemes said, I'm on a quick lunch break, stepping out to talk to you guys about a very important issue that can affect each and every healthcare provider within our states. A little bit of background on the Kentucky Nurses Association. They represent 90,000 nurses within the Commonwealth, and we represent each and every one of those nurses, regardless of their specialty or field within nursing. And there are 80 different nursing practices in this great state alone. The nurses in general comprise 53.3% of the entire healthcare workforce, and nationally there are 4.4 million nurses. Like other healthcare professions, the need for nurses is great, and it's very important to focus on the healthcare provider shortage to attract individuals to come into the profession, as well as retain the current healthcare providers that are in our current workforce. One way that we can do this is to eliminate the possibility of being criminally charged for medical errors that happen. Removing this barrier not only helps to retain healthcare providers by decreasing those fears of criminal ramifications and makes healthcare professions more appealing. It also, and more importantly, it increases patient safety and it removes those red tape barriers to and the fear of reporting those errors. A quick quote from Don Newman. He says, making errors, people make errors, and those lead to accidents. Accidents lead to deaths. The standard solution is to blame people involved, right? If we find out who made the errors, we punish them, we solve the problem, right? Well, wrong. The problem is seldom the fault of the individual and more of the system. If you change the people without changing the system, the problem will still continue. I'd like to clarify this concept a little bit further and relate it to patient safety by using the Swiss cheese model. I don't know if anyone is familiar with that, but it's the Swiss cheese model of accident causation. This model is used in many professions in risk analysis and risk management, again, in multiple professions outside of healthcare. It compares human systems to multiple slices of Swiss cheese with the little holes in them. The holes represent weaknesses or failures within the system, and then the slices represents each and every layer of defense within that system. The accidents occur when the holes in the slices align, and it allows a hazard to pass through those holes. The stack of cheese represents an organization's safety system or fail-safes that they have in place. And the slices of cheese prevent hazards from resulting in harm. But every now and then, it lines up just right and allows that harm to come through. The holes represent both latent conditions, near misses, and those that are accidents waiting to happen, and active failures where you see the provider mistake or medical errors. The Swiss cheese model reveals the importance of improving latent or near misses and decreasing those conditions so they don't cause harm. Voluntary reporting systems are in place, and they provide submissions or reports of unsafe conditions and errors so that system can be improved and prevent cause of serious adverse effects or deaths. The problem here lies within the fear of retribution. If you report something, that you're gonna be criminally charged just for trying to do your job and take care of your patients. So we feel like this bill is needed to address what's happened in other states. We don't want it to happen here in Kentucky. When an error occurs, and any healthcare provider is always going to be disciplined by their employer, by possibly losing their jobs, or even their state licensure board by the removal of their license. That's deterrent enough without the possibility of criminal charges on top of this. Again, I thank you for your time and your attention, and I look forward to any discussion that we might have.
Thank you, Mr. Chairman. I think that wraps it up. I would note for everybody on the panel, but especially I think our lawyers who practice in this area, one way I think you can look at this is it kind of codifies what common law is. It doesn't remove the ability of the prosecutors to go after bad actors who engage in things like intentional acts, but it effectively codifies common law to protect our healthcare providers. It's very important to them, especially important to our nurses.
Thank you, Representative Nemus, and thank you, Ms. Hester. I did have a question related to whether or not we have had an incident of this in Kentucky. It sounds like we haven't, but
No.
Ms. Hester did reference other states.
Right.
So I'm presuming that there was an instance in which
Right. This is
this
something
situation
that this is
occurred in
something that
another
national
state.
nursing associations are discussing, that it's important to them. We're not aware of it happening in Kentucky, and we don't think we should wait for it to happen in Kentucky to protect it in this way. And again, this is a very close to the common law, so it would just make it in statute to provide that protection, so no judge could change it.
Sure. Representative Rawlings has a question.
Thank you, Mr. Chairman. I had a story and a question. So I had a friend that was very sick during COVID and went to the hospital, and in the hospital became progressively worse. He's married to a Japanese lady, and she doesn't speak English well, so he had a power of attorney friend there. It was late during COVID when people were questioning the treatment of remdesivir. So the wife and the power of attorney said to the staff, please don't give him any remdesivir. They disregarded those instructions and gave him several doses of remdesivir. They told him, the power of attorney friend told him they didn't want him put on a ventilator. Despite that, and they made a big point of it, and so did the patient, I don't want a ventilator. Despite that, they put him on a ventilator. So the day after they put him on the ventilator, he passed away. So how does that play into this bill? I feel like many people would consider that criminally responsible for his death, and the family does. and as many friends do. So how would you handle that if
Yeah.
this bill becomes law?
So, Representative, I want to note that that would have this bill would have no bearing on that family's right to recover civilly if they had a right before. This doesn't touch it at all. It wouldn't touch the opportunity to go after any professional's license if there was misconduct in that way. This bill doesn't speak to that or change anything at all. With regard to the facts as you outline them, I don't know the facts other than what you've just mentioned. If there's intentional conduct that violates the law, then this doesn't protect those professionals. And so as you outline the facts, and again, I'd want to go into the facts more in depth before you're a lawyer like I am. We want more facts if we can get them. As you've outlined the facts, I don't think this bill would touch that situation. If there's been an intentional violation of the law, then this bill doesn't touch that. It only protects them if it's a mistake. There's honest negligence, things of that nature.
Okay.
So I don't think your situation would be altered in any way if this were the law.
Okay. All right. Well, thank you.
And I don't want it to be altered in any way.
Senator Wheeler.
Mr. Chairman, I had the same question that you did. I wondered if there are any of these charges that have been brought in Kentucky, so that's been answered. Thank you.
Thank you. Representative Moser.
Thank you, Mr. Chairman. Thank you for bringing this bill. The only example I can recall that's a recent occurrence of this having happened is in Tennessee. Is that kind of the impetus behind this bill? Either of you can answer.
Yes, ma'am.
Okay, thank you. Yeah. I think this is important. It's as you've said, there are already penalties for any sort of medical error or even malpractice, and this excludes anything intentional. So I appreciate it.
Senator Berg.
I'm sorry, and I should have done my research last night, but I didn't know that we were talking about a specific incident, or that this was coming out of an incident in Tennessee. Could somebody just give me a little bit of background about that case, what the concern was?
So I'm going to address the systems errors that I spoke about earlier whenever I was speaking on the Swiss cheese model. There was an incident where a patient had a sentinel event, and for all of you that's not medical, a patient had passed away due to the incorrect drug administration. There were several fail-safes in place at the hospital in which that it occurred, and that nurse, after this happened, was brought forth on criminal charges.
Thank you. That explains a lot why we would need something like this.
Representative Flannery.
Thank you, Mr. Chairman. I have a comment and then a couple of questions, if you could indulge it, please.
Yes, proceed.
Representative Nemes, I would agree that basic negligence, common law negligence, doesn't rise to the what we would call the mens rea level for a criminal case, so I'm supportive of that. Reading through, looks like subsection 3 talks about gross negligence, wanton, willful, malicious, or intentional misconduct. I'm just trying to think through different fact patterns, playing law school here. What about assault and battery? Do you think that would be covered by that? Because I can foresee maybe some situations where you may have something that falls within those concepts. Do you believe that's covered? And then second question, where it defines healthcare provider, is it inclusive enough to pretty much cover everyone in any institution that provides healthcare services?
I think it is, and when we testify on this in the session, I'll have a list of everyone, all the particular providers, and not just a reference to the statute. With respect to the assault and battery, I think those are intentional crimes. I think the mens rea there would be an intent. We've got public defenders in the audience, and they can certainly come up here and correct me if I'm wrong about that. But my understanding is that assault and battery are intentional crimes, so this wouldn't affect that.
Thank you. Is there any? Senator Berg.
Thank you. I'd like to just make one more statement, because this is something actually I've been thinking about a lot recently, in part because I'm getting ready to write an article about it. But one thing I want to just make sure that people understand is that medicine and the practice of medicine is really different than like what we do here. In medicine, if you make a mistake, you are obligated to acknowledge it and absolutely do anything and everything you can to fix it. Those are your responsibilities, to acknowledge that you made a mistake and do everything you can to fix it. Anything that would make somebody feel like they need to cover up a mistake is antithetical to the good practice of medicine. It is not what we do. It is so important for people to understand that in medicine, the actual truth matters. And if you lie, you're gone, because we can't trust you anymore. So, thank you.
Thank you, Representative Petrie.
Thank you, Mr. Chair. Are there any other service sectors in our economy that we extend this immunity of criminal liability?
Chairman Petrie, I'm not sure about that. I'll have to look. I would say, when you say we, I assume you're meaning the legislature by statute. I don't know the answer to that. I know we have lots of these protections in common law. This was brought to us because of the particular situation in another state, and obviously how we think it impacts us, and also the unbelievable shortage of nurses that we have. So I don't know the answer. I'll get you. I'll look.
Yeah, if I may, Mr. Chair.
Yes, you may.
Fair enough, and if you can, that would be great. So the point behind the question is this: I'm very familiar with the situation in Vanderbilt. Followed it as it was moving along over the years. But I'm wondering whether or not we're getting ready to extend an immunity in a service sector that we're going to have 6 to 67 lined up right behind it afterwards, saying we need the immunity also. So we need to be prepared for that. Or is this distinguishable by the nature of the service being rendered? That's why I asked. Thanks.
Representative Burke.
Thank you, Mr. Chair. Like probably everyone in the public, the facts of the Tennessee situation were not known to me without some research. And so I want to extremely briefly recap what happened there and then ask a question. So in Tennessee, a nurse was told to retrieve a certain medication for a patient. She retrieved the wrong medication. She then entered it into a system that tells her how much to dose the patient. She was given several red flags by the system. She overrode every single one and eventually gave a fatal dose of the wrong medication to someone who was about to be discharged. It's an egregious situation, to be certain, and clearly I understand the nurse anesthetist explaining that that's a system problem. But my question is this. So with Section 3 of this bill, we're not limiting for gross negligence, wanton, willful, malicious, or intentional misconduct. Would the nurse in Tennessee who made this egregious deathly error be subject to criminal liability in Kentucky?
There's no way of knowing without knowing more than that. You have to look. What was the proof presented? Did she act in a way that was intentional? Did she act? Was it just an honest mistake? There's no way of knowing from what I know today. I'd have to dive into the actual proof that was presented. But in that kind of situation, you could present, you could make a case, if the facts align correctly, where a nurse would be grossly negligent, in which case she would not be shielded from criminal liability that this bill would protect. But that's a high standard, as it ought to be.
Agreed.
And so that's what we're trying to do here is we're not trying to protect the situation where there's gross misconduct. We're trying to protect just honest errors.
All right, thank you.
Thank you, Representative Kulkarni.
Thank you, Mr. Chair. Thank you for bringing this bill. I had just a quick question also regarding Section 3, where we talk about not limiting liability for negligence, wanton, willful, malicious, and intentional misconduct. We do have a separate definition for recklessness in Kentucky statute, and I'm wondering whether or not whether that was considered as part of this or if it was intentionally left out, and if so, why?
I would mention, you said we have the Section 3 covers negligence, wanton, or willful. I just want to make sure that we add the adjective there is gross. Oh, it's only gross negligence.
Right,
Okay.
right.
So the recklessness, I need to go back into the criminal statute and look at that definition. As I sit here today, I see no reason why that can't be added in. But I want to look at the actual language of the definition in Kentucky law.
Yeah, I just wanted to understand why it wouldn't be there and whether that would, leave out
Yeah,
potential.
it could have been
group.
just my error of not including it, and I'll make sure that. And again, we're only trying to protect honest errors, and so recklessness, as I sit here, probably should be in the subsection, but I don't want to commit until I actually look at the definitions in KRS.
Thank you. Thank you.
Representative Blanton.
Thank you, Mr. Chairman. Just a quick question for clarification for myself and actually everyone. This will not prevent a criminal investigation. It just changes the standards that someone would have to meet in order to be charged criminally, which is gross negligence, wanton, willful, malicious. So they could still be charged if they meet those criteria, and it doesn't prevent them being investigated to see if they fit that criteria. Am I correct in that interpretation?
Certainly, Representative, and I would like to note that I don't think that this is a change. I think this is a codification of common law to make sure there are no changes by courts. This I believe is the law in Kentucky, and it ought to be. So I want to codify it in statute.
Very good. Thank you, Mr. Chairman.
Thank you, Representative Blanton. Thank you, Representative Nemus and Ms. Hester, for your presentation. We appreciate your time this morning, and we'll take up our next agenda item, which is the Department of Public Advocacy update. And we have Damon Preston and B. Scott West with us to provide that update. And if each of you are well known to our committee, but if you would introduce yourselves, and then you may proceed.
Thank you, Mr. Chairman, and all members of the committee. My name is Damon Preston. I'm the public advocate, the head of the Department of Public Advocacy.
And I'm Scott West. I'm the Deputy Public Advocate.
It's an honor to be here this morning. We presented yesterday for a pretty good amount of time at the Budget Subcommittee. And so for those of you that were here, this is going to be a little bit of a repeat, but I'm going to try to speed through the parts in common with yesterday. The mission of this committee is different in some ways, but is not different in others, because I think I view the role of this committee in part to be overseeing how the justice system in Kentucky works. And I hope you would agree that the justice system in Kentucky can't work without a functioning public defender system. I had a good conversation yesterday with Senator Schickel on kind of the origins of the public defender system, but whatever the origins were, in 2023, we are essential to the workings of the system. And so I'm going to talk about that and some of our challenges this morning. I want to first start with just some of the numbers. These are 22 numbers. We have not yet completed our fiscal year 23 report. But overall, we're responsible for representation in over 140,000 cases. Our average caseload of 375 is not as high as it used to be about 10 years ago, but it's higher than it was in the depths of COVID. The criminal justice system is the number of cases is rising again. That average caseload is based on full staffing, as I'm going to explain in a minute. We have not had full staffing since before COVID, and we are far from full staffing today. We are a very efficient system, handling cases, criminal cases, everything from juvenile and traffic cases that can result in jail time, all the way up to robberies, sex cases, and even capital murders. And all of that together, we handle at an average of $435 per case. So we are a very efficient system. You can see the different kinds of cases we have there. There are national standards for how much appointed defense counsel should be handling as far as cases. And when you put all of those, it's not simply a number of cases, but it's types of cases. And when you put all that in the formula, it spits out that we're at about 36% above national standards. And again, that's if we're at full staffing, which we are not. So we're even higher at our current staffing. I want to thank you for the raises that you provided last year. It was essential to stopping a crisis of turnover that we had. And I'm going to talk about the success of that. I want to thank the Personnel Cabinet as well for helping us in implementing those raises. We raised our attorney starting salary from $48,000 to $52,000. $52,000 is still way low, but symbolically getting above $50 was a big deal to us.
and so we're happy to be there. And we accomplished the raises by creating a salary schedule for everyone that works for DPA, attorney and non-attorney, and we're able to give raises. And our average raise overall, both for attorneys and non-attorneys, we provided raises to almost every DPA employee, and the average overall was 22%, but it was 22% for both attorneys and non-attorneys. They were equally spread. So our attorney turnover, this is a 4 years spread into 5 time periods, and you can see that in 2020, when COVID was at its peak, we had lower turnover then than average because people didn't lose jobs during those days of didn't leave jobs during those first few days of uncertainty. But then in 21 to 22, a year period, we had 109 attorneys. For context, all of DPA has 330 attorneys, so it's almost 1 in 3 attorneys that walked out the door in a 1 year period. After we gave the raises, which is the next period, that was cut in half to about 55. But you can see that even when it was cut, we weren't back to 2019, which was a normal year. That was 52 was about our normal turnover rate. So we didn't even get down to what we were pre-COVID. And then I updated this before yesterday's session to show that in this year it's creeping back up to 67. But unfortunately, in my email this morning, I learned of 2 other attorneys that have left. When I put that in the formula, it raised our annual rate for this year up to 73. So it is definitely trending back upwards. We've lost 7 attorneys in the last 2 weeks, and so this is a crisis. If you total up every number on the board here for this 4-year period, we're at about 300 attorneys we've lost in the last 4 years. Now, obviously, that's not 300. That doesn't mean we only have 30 people that were here in 2019. We've had people that have come and left during this time period because turnover continues even for new attorneys that just don't stay very long. I want to give a quick example of our challenge here. So this is our pay schedule for this year. I mentioned our starting salary last year went up to 52. We raised it 3% to go to 53,560 for this fiscal year. The numbers in green here on this pay schedule are the midpoint. I'm sure you understand that as 18A employees, I'm bound by the pay ranges that the Personnel Cabinet dictates, and I can't appoint someone at a salary higher than midpoint. So those, our pay schedule has essentially hit the ceiling for those. But at this moment, if you're an attorney here and you're looking for a job, and you go on Indeed.com, you'll see that the Jefferson County Attorney is offering a starting prosecutor. A position starts at $68,500. If you look at our pay schedule, someone with 20 years of experience is not being hired by us at $68,500 unless they can handle the highest cases. My pay schedule doesn't go down further in the staff attorney 3, but if you're able to handle the most complex cases and you have significant experience, we can hire you at that rate. But someone fresh out of law school, I can't come within 15,000 of that with our available funding and structure. And even if I had the funding, which is part of what I asked the committee yesterday for, under the current class specification, the salary, and pardon the best I could do with a mouse and handwriting what the annual salary is here, $62,000 is the most I could pay a law school graduate under current class specifications. So I can't come within $6,000 of the prosecutor's pay offer under current salary or under current structure. So one of my asks is that I be given the freedom to use our budget. I'm obviously going to live within my budget, but if I have money, I should have the freedom to be able to pay attorneys, professionals more, and pay whatever I need to fill a position in the courtroom. Overall, I'll just point out that prosecutor funding, even excluding all AG, and the AG certainly has prosecutor functions as the top prosecutor in the state, but even excluding all AG funding, prosecutor funding exceeds indigent defense funding by more than 60%. That you can see the trend over the last decade there. It's been pretty consistent at around 60 to 70% in excess. Because of that, and because prosecutors are not part of 18A as far as limited in the salaries, about 1 in 4 attorneys who leave DPA go to a prosecutor's office for a higher pay. they have freedom to say, what are you making at DPA? I'll give you 5,000 more. And I have no ability, again, even if I have the money, I have no mechanical ability to match that. And so they leave for the higher pay. Another challenge that I just want you to understand the context. There are fewer lawyers coming out of law school now than there have been in 40 years. This only goes back to 2000, but this graph exists back to the 80s. And the number of law school graduates last year was the lowest it had been since the mid-80s. So there's just not enough lawyers coming out. Among those lawyers that come out, a pretty small subset are interested in public defense work. And so that it's a very competitive market. This I want to go through just real quickly. Because we have turnover, we write contracts for private attorneys to handle cases that, because we don't have a public defender, so private attorneys handle those cases or dockets. We then try to recruit. We try to recruit experienced criminal defense lawyers, but those lawyers are the ones contracting with us, and their response is, why would I come work for you? You're paying me by contract. Why would I take all the hassle and limitations of state employment when you're paying me anyway? So we can't recruit, so we have to write more contracts. And then what happens is our current employees say, now wait a minute, I could go out there and make the same amount of money and have a private practice and not be a state employee. I'll just resign. And as I mentioned yesterday, this is not hypothetical. We received a resignation letter this week from one of our attorneys that said this exact thing, not quite with the pointedness that I'm saying it, but said in the resignation letter, it's too stressful to be a public defender on staff, but I'm going to open private practice and I'll be happy to handle any contracts you can give me. So this connection is not hypothetical. We are losing people, and it's a vicious cycle. The more we lose, the more we contract. The more we contract, the more we lose. And the only way out of that is to raise the public defender salary and to make it attractive to stay and, even better, become a public defender. So that's part of what the need is. It's round 2 of raises. I hate to come back asking for this, but while we've been raising, the rest of the world's been raising as well. Prosecutor salaries have gone up. Private legal market rates have gone up. Inflation has gone up, which means the raises weren't as meaningful as they might have been at a different time. So I think being competitive is not enough. We should incentivize being a public defender and incentivize staying a public defender. And I created this slide, I think 3 weeks ago in preparation for these presentations to say that I think we need to standardize defender and prosecutor salaries at $70,000. When I wrote this, I didn't realize that the Louisville prosecutor was already offering $68,000. So this is not an outrageous number. And so I think the starting salary should be $70,000 for a professional who's representing clients in the Commonwealth. But also the standardization is something that I would invite further conversation about, because the idea that a good public defender is serving the Commonwealth in a courtroom, but the prosecutor on the other side has not only more funding but more freedom to take that person into their employment by offering them a raise. I would like standard salaries. We've got a pay schedule. I would love to work with the Commonwealth and the prosecutors to provide funding so the pay is competitive for both sides, but that it's standard. So someone that has 10 years of experience in criminal law gets paid the same at prosecutor. Now, I'm not talking about the elected officials. They'll have their own salary, but the assistants with similar experience should make the same amount of money, and then you go where you want to go. If you want to prosecute, you work for them. If you want to defend, you work for us. Real quickly on recruiting, this is going to be one of my big asks for the spring. Hopefully it can be put in Chapter 31 in DPA's statute, but if not, maybe in the budget. Every year we lose recruits. We recruit nationally, and we lose recruits who say, I would love to work as a public defender in Kentucky. I just can't get from here to there because they're in law school. They've already incurred tens of thousands of dollars in debt. They have to pay for bar prep. They have to pay for the bar exam. They have to physically move here. They have to pay their first and last month's rent. If they start for us on August 1st, they actually don't get a paycheck until August 30th. And when they get that paycheck, it's our paycheck, which is not very high. And so there's this hole, and they say, if I could get to September, I can work for you. Once I'm getting paid regularly, I can pay my rent. I can do everything, but I can't get from here to there. And so what I'm asking for is, as part of this, not necessarily additional money, but authority to spend the money I have in a recruiting and retention program that would authorize payments when justified to people, basically a signing bonus to say, I'll help you with your move, I'll help you with your bar exam, I'll help you with your first month's rent. Not getting into the detail, I'll basically give you cash for what you need. And in exchange for that, you'll commit to me that you'll work for us for at least 2 years or 3 years. But we'll come up with a commitment, and if they stay part of that, they pay part of it back. If they leave within 6 months, they have to pay the whole thing back. And this would be completely transparent. I didn't put it on here, but my proposal for this statute would be that I would explain to you in advance the criteria for these payments and explain to you after the fact every single payment we made. This would all be transparent. We're not talking about some hidden slush fund here. This would be a program that's run out of our department for the purpose of improving services to the Commonwealth. Now, let me quickly run through House Bill 568, which came through Judiciary, I believe, last year and became law, would bring the Louisville Public Defender's Office into DPA on July 1 of 2024. Here's what the current status of the Louisville Public Defender's Office is. DPA is providing about 56% of their funding, a little over $6 million. Louisville Metro Government's providing a little less than $5 million at 44% of their overall funding. That's for this year. As of July 1 of 2024, that Louisville Metro Government contribution will go to zero. And so we will be coming and asking for funding, and more on that in just a second. The Louisville office, if they had full staffing, would be 129 employees with 78 attorneys. In reality, because they've had turnover same as us, and because to a certain extent, because of the uncertainty of what's going on with the transition, they've had a number of resignations. So their total staffing is around 90 to 100, I think closer to 90 probably. And they have 50-ish when I wrote this, but now I think it's less than 50 attorneys on staff there. They are doing the same as us. They're doing private attorney contracts through a program that they have called TWRP. And in 2022, the Louisville office was assigned 21,000 cases. So here's what I need for that. I need funding. This legislature has required this path now. And so step 2 is just as important as step 1, and that's to fund it. And so here's my estimated funding request. That's replacing the about $5 million that Louisville currently pays, so the state would need to pick up that tab. And then to make the office a state government office would need about $5.8 million in addition to that. And the assumptions of that are that we can get them back to full staffing, which is essential, that the employees will come into the state retirement system, and that they don't have to move. My doomsday scenario, if we don't provide that funding or provide assurances that we will take care of the office, is that those 20,000 clients on July 1 are not going to have an attorney. Because I can tell you, we don't have extra people in DPA to send to Louisville. We don't have enough people in Pineville right now. So we don't have extra people. If the people that are in Louisville serving at a very high level through the Louisville Public Defender Office right now, if they leave, we don't have a plan B. So we need to communicate to them that that office is going to be not only sustained, but actually improved through this service, and that they should stay with us and serve the clients. They are valuable public servants in Louisville, and I want them to work for DPA next year and hang around. So what we need there, and Representative Nemes has talked to us, and he's been a great supporter of this effort and of DPA specifically, and we've discussed this, what I'm calling a smooth transition statute that will assure the employees in Louisville that they will have a job, that they will have merit protection, that they won't take a pay cut, and that they'll have insurance and all of the things that they're worried about. Imagine in your job, if you were told 6 months from now you involuntarily are losing your job, that creates anxiety on what am I going to do? How am I going to have insurance for my kids? Am I going to have a gap in pay? The smooth transition statute would take care of those issues. So now I guess I'll pause for a second. I'm going to go now to other things that challenge, but if it's okay, Chair, I'll open to questions on the Louisville situation because that's a big deal.
That's fine, and Representative Nemus, you're recognized if you have a question about that.
Thank you, Mr. Chairman. I want to appreciate Mr. Breaston and Mr. West for being here today. I want to know, just as a way of quick history, and I'll be very quick. So about 60 years ago, the U.S. Supreme Court said that these kinds of services are required for indigent defendants. At that time, we had 3 offices in Kentucky: Ashland, Lexington, and Louisville. Ashland was covered by the state system when the state system came on, a little bit after the state system came on board. And then about 15 years ago, Lexington's system came on board. Lexington's office came on board with the state system. Very smooth transition. There were, anxieties and so forth as there is today. And then now, the entire time since we've had this system, as both the state and the local boards, public defender, state board and the public defender, local Louisville board has mentioned in a joint statement, the effort has always been to get the Louisville office under the umbrella of the state system. It is I think the crown jewel system in all of the country. Kentucky's is, and so this is the next step. I would note that Louisville has been funding at about $5 million this office for many years. It is 100% a state obligation. Louisville has funded the office, and no other office has, at least in the last 15 years since Lexington's. So it's an obligation we have. We need to make sure that we have the appropriate transition. Last year, we passed a law requiring this to happen on July 1st, 2024. We're moving toward that. We're meeting very frequently to talk about pension issues, to talk about application issues, all the things to make sure the transition is smooth. So the person who goes into Mitch Perry's courtroom in Louisville on June 30th goes into Mitch Perry's courtroom on July the 1st, and her thought is, how can I best represent my client, and not, oh my gosh, what's going to happen with my particular job. So we're getting those things done. It will be done appropriately. It will be done on time. Working very hard and closely with my friends here and with the Louisville folks and with the people in the Bashir cabinet. And so I'm very confident that this will be done like it was done in Lexington and in Ashland, and like it must be done in Louisville. Again, it is a state obligation, and so I wanted to just give that particular history. And so I guess you and I have talked in my office about this, and you informed me that this can be done by July 1st. It will be done by July 1st. So I just want to see that you make that commitment public. You and I both make it together that this will be administratively ready to rock and roll, and the bow will be on it, and we'll be ready to make this transition on July 1st, 2024.
Absolutely, Representative Nemus. We are so thankful for your support. This is going to happen by July 1. It's the law, but it's going to happen well by July 1 because of the efforts that you're leading through collaboration. We've always had a good relationship with the Louisville office, so this is not that we're having to break down walls to get this done. We're working with them. The short time frame creates some challenges, and it certainly creates some anxiety, but there's nothing insurmountable. We're going to get this done. Dependent on the funding, assuming the money comes through, and I have full faith that it's going to, this will be done at a high level, and we'll be ready on July 1.
Well, thank you, and you can continue with your presentation.
Thank you very much.
I'm sorry, Representative Petrie has a
Thank you, Mr.
comment
Chair.
or question.
Thank you. There are 2 issues that we're dealing with here categorically. One is the transition of Louisville that's just been discussed. The other, though, precedes it in time, and that's from the 22 budget cycle when there was additional money put into the DPA as a Band-Aid mechanism. And we have talked before that was done, while it was done, and afterwards about a reorganizational structure for DPA, not just the funding mechanisms, not just the pay scales, not just the 18A issue and all those type things. And as we approach the 24 budget cycle, I'm very anxious to see a bill draft that addresses those things separate and apart from the Louisville transition. And in some senses, it has to precede the Louisville transition because we don't know exactly what pay scales everyone's going into or what structures they'll be walking into. So I don't want to lose focus on the historically precedent issue.
Yes, and we appreciate the good conversations we've had with you and with other members of the House, mostly, I think, on those topics. We are open. we've had good conversations on where we're heading. Yesterday at the budget subcommittee, I previewed some of the reorganization that's going to be necessary to accommodate Louisville and the growth of the agency. The conversations we've had will be part of that. So I actually foresee in the spring probably having at least 2, if not 3, bills related to DPA's organization. Some directly tied to Louisville and some more what you're talking about.
And Mr. Chair, if I may,
Okay.
that's great, just to set the timetable expectations. We need to have those bills ready before session so that we can take a correct physical accounting of what's implicated so that it can be prepared in advance of the session coming up in 24.
All right. Thank you.
Representative Cole Carney.
Thank you, Chairman. And I know we heard this yesterday in the BR sub, but I just wanted to thank you all for your detailed presentation. I'm a Louisville legislator, and I know certainly during last session there were a lot of questions, a lot of anxiety, as has been discussed. And I appreciate all of the openness in the discussions that we have had about this transition and your focus on the employees. And so I want to also reiterate a point that I brought up yesterday in terms of retention and recruitment, that you would be bringing in attorneys or keeping attorneys, very crucially needed attorneys, into a more stable system, into a system that is a little bit more sustainable than it is now. So I just wanted to reiterate that discussion from yesterday. Thank you.
Thank you.
Thank you, and you can proceed.
I want to go through just real quickly, and I'm not going to go too long on this, but some of the challenges we're facing right now, some you may be aware of, some you may not. First, we have a challenge on representing children these days. If you've been at Juvenile Justice Oversight Commission or perhaps previous meetings of this committee, you know that DJJ is currently dealing with challenges related to where juveniles are placed. Northern Kentucky currently doesn't have a juvenile facility for the most part that can take children that are arrested in Northern Kentucky. Louisville shut down the juvenile facility there and has very limited capacity now. And so what's happened is juveniles who are in detention, one of 2 things is happening. Either a lawyer is having to essentially spend an entire day to travel across the state to see 1 or 2 clients, or in reality, and frankly, more likely, the attorney's just not seeing the kid. So our most vulnerable clients, 14, 15, 16-year-old kids facing sometimes serious felony charges with transfer possibilities and possible felony convictions, or even just commitment to DJJ and being out of their community for an extended period of time. Those children essentially don't have a lawyer. Our lawyers try to do Zoom. We're advocates of virtual meetings and virtual hearings within reason when it's voluntary and works for everybody involved. But a 15-year-old child that's had a rough upbringing and is involved in the juvenile justice system, doesn't have family support, some face they've never seen before on screen saying, I represent you and I want to look out for your interests, that's not going to have the impact it needs to have. So we need to see clients in person. It's beyond the scope of today's purpose to talk about solutions for this, but just know that this is a real challenge we've got right now. It's more challenging for the clients who don't have an attorney, but it's challenging for DPA to meet this responsibility that we badly want to meet, which is to provide quality representation to children. Another challenge that's been discussed here very much, but I want to make sure our voice is heard, is virtual court. There are still many courts where incarcerated defendants are required to attend court virtually. COVID was the justification to start that process, but it's continued, and COVID is no longer the justification. It's staffing or efficiency or reduced costs. There's a real cost to the system if people sitting in jail don't get to come to court. And to require someone to attend court virtually is, I think, inconsistent with the foundations of the court system.
Pretrial matters, though, right? For the most part, are those only in most jurisdictions that you're talking about? Those are
I'm not
pretrial.
I'm not aware of any
virtual appearances.
jurisdiction that is handling trials currently virtually. but it's for all pretrials in some areas. So anything short of that, I've been present in a courtroom where guilty pleas to 10, 15 years in prison are taken virtually, and I've looked at the face of the client on the camera and I thought that person has no idea what's going on, and they're pleading guilty to some for 10 or 15-year prison sentence. But even aside from that, so that goes to number 3 here as far as defendants not meaningfully participating in the court hearings. But the jail costs are increased because studies show that if someone is appearing virtually before court, the court is less likely to reduce bond or to release a defendant. And I don't know why I put DPA work here in those cases is doubled due to pre-court and post-court jail visits, because if we know a virtual court appearance is going to occur, rather than being able to talk to them in the courtroom, we have to go to the jail before, explain to them what's going to happen. The virtual court appearance happens. They're in a room with 20 other people at the jail. They can't hear, they can't see, they don't know what's going on. So then we have to go afterwards and explain to them what happened. It doubles our work when it comes to client relationships. And imagine, put yourself in this position to a certain extent. Imagine any legal case you've got. You're suing somebody, you're a defendant in a civil suit, or you're in a criminal matter. And the court tells you you are not permitted to come to court. You have to attend virtually. You'd say, no, I want to be there. This is my life. Whatever, even a minor civil case, you'd say, I want to be there, especially if the other party's there and the other judge is there. Well, that's not happening for our incarcerated clients. And so this is something that I encourage the legislature and this committee to look into expanding virtual court as an option, but I would like it to be, frankly, prohibited as a mandatory proceeding for people that are in custody. I think if somebody's in custody, their liberty's at stake. For anything other than a minor scheduling hearing, if there's anything substantive that happens, I think they need to be in court. Senate Bill 90 that came out of this committee created the Behavioral Health Conditional Dismissal Program. This is being rolled out across the state. Many of you are involved in this, but some may not be. There are 11 sites that this is pilot sites. This is to help people with mental health or substance abuse issues avoid the criminal justice system and be diverted out of the system. One issue they found as they're rolling this out is that people have barriers. Sometimes it's a transportation barrier, sometimes it's a health barrier, sometimes it's just a money issue. And so BHDID, who's running this, says that they need what's called barrier relief administrators. That's their title. And they asked if DPA would be willing to house these. We are, because it's consistent with trying to help our clients avoid conviction. But it's kind of outside our mission, and this goes somewhat to some of the conversations I've had with Chair Petrie as far as what's the purpose of DPA and what's not the purpose of DPA. But this would work for clients, and if it's not us, it needs to be somebody. So this is something that we would need. They would provide the funding for the positions, but it might add some cost to us as far as space and things like that. Plus, we would need authorization to play this role. So I just want to put that on your radar for later. And quickly, I'll just go through legislative priorities. I've had good conversations with I think a majority of people on the committee, but there are some of you I've never had a conversation with. DPA wants to be a resource when it comes to criminal law legislation. We certainly have a perspective, but I hope you understand that we want to provide accurate information. And if I know a natural thing to do when a criminal law bill is filed is let's call my Commonwealth attorney, let's call my county attorney, and I absolutely encourage you to do that. But I hope that right after you hang up with them, you'll call either me or Scott or your local DPA supervisor and say, what do you think of this bill? Because just like the adversary system works in the courtroom, I think it's also helpful to have multiple perspectives on criminal law legislation, because sometimes there are collateral effects, or sometimes we may have a suggestion that that's a good idea, but it might be better to do it just this different way. And so before I get to the priorities for the next session, one thing I do, if you've heard my annual presentation for years, is I do keep a scorecard on legislation. A lot of organizations do that. Our scorecard goes to how many bills were passed and how many statutes were changed that either created new crimes, enhanced penalties for existing crimes, or expanded the elements of existing crimes. And I compare that to how many crimes did you eliminate, how many crimes did you narrow, how many sentences did you lower. Your scorecard this year was 26-6. You created 12 new crimes, you expanded 10 existing crimes, and you increased punishment for 4 existing crimes. You did eliminate 2 crimes. Those were both in House Bill 349 related to HIV, which were welcome that those crimes were eliminated. I'd never represented anyone charged with those crimes, but you did get them off the books. You narrowed existing crimes, including possession of marijuana and possession of drug paraphernalia, through the medical marijuana bill. And you decreased punishment by expanding expungement a little bit, and a very narrow decrease in the incest statute that probably nobody realized. But when I looked at it, I thought, okay, there's a sliver there that punishment went down. I promise not to say that beyond today, that you did something in the incest statute that would decrease punishment. But overall, the scorecard 26-6. I say this just to say, as we have discussions about over-incarceration or expanded reach of the criminal justice system, we talk a lot about criminal justice reform, but every year we go in the other direction. So our priorities for the next year, none of these should be a surprise. Targeted PFO improvements. I think our PFO statute is too broad and too severe. Also think we should continue the conversation on pretrial release reform and a comprehensive sentencing perspective. All I mean on that is we pass all these different laws, but we don't give thought to how they work together. And there was a bill, it was the hazing statute, that one of the new crimes committed was the hazing bill. And that had language in it that I think we had recommended, and if we didn't, we certainly supported it, that said if this person is also charged with wanton endangerment, then and hazing, they have to run concurrently because they're two ways of saying the same thing, and they shouldn't double the penalty. That's the kind of perspective that I would like us to have more conversation about on how the stacking of penalties creates undue leverage and eliminates a reasonable opportunity for trial. So that's what I mean by comprehensive sentencing. Just think about how these work together, and let's come up with some limits on how many different crimes can be stacked. I believe that's the conclusion of the information, but I want to end by just saying we are making a difference in your communities. We are representing real people and providing real relief. Even when somebody's convicted, we're providing services that make the system fair, that make sure somebody has an adequate opportunity for their voice to be heard in court, and I think that's important. Real quickly, my wife is the executive director of Habitat for Humanity in Scott County. And she told me of a person that called her a couple of years ago. They used to run a restore that used furniture and things. And somebody called my wife a few years ago and said, "I've got some furniture I want to donate. It's a little beat up, but it's good enough for a poor person." And my wife told me that of this phone conversation. And I mean, I'm certainly offended by the concept, but then I thought, how does that relate to the public defender system? We can have a view of the public defender system that we say, let's just make sure it's good enough for a poor person. Or we can have a view that poor people in the Commonwealth deserve a quality defense. They don't need, I put a good, I don't know if that's IKEA, or I put a good functional piece of furniture there. That, nobody's asking for luxury, but we need a fully functioning, adequate defense for even poor people in this state. And I think if you or I were charged and we would hire the best lawyer we could afford, I think poor people should have a good, competent defense, and that's what I'm asking for today. So thank you for your time, and I'm happy to answer any questions.
Thank you. Very, very profound. I think I had a couple of bills last session that may have fixed all the issues for DPA. So
and we appreciate those.
And we appreciate your presentation. I did have a couple of comments and questions related to the public service loan forgiveness program that the federal government runs. To what extent does that help or assist DPA in recruiting young attorneys, if anything, and what level of participation or what level of promotion, I guess I should say, does DPA use in trying to make folks aware of that who might potentially be good public defenders?
We do use that. We do try to make everyone aware that has student loans and who doesn't have student loans. That program is out there. I think the program, as I understand it, is if you work in public service for 10 years and you make your payments at the end, your balance is forgiven regardless of how big it is. We have a proposal that we would like to expand it and help assist in paying student loans while they're in that payment process. The problem is that there are no programs out there that are public defender only. And that doesn't help us when it comes to losing to prosecutors or losing to other public service jobs, because that becomes a wash. So really, it becomes about the salary, or it becomes about the workloads, or some other factor. We would like to have something exclusive to DPA that allows us to do a sort of a reimbursement up to a certain amount for a certain period of time, that would allow us to go ahead and on proof shown that you've paid, you can get reimbursed up to a certain amount of money for that month, and have some kind of minor clawback in it. I mean, we don't want to be punitive, we don't want to be onerous, but someone who participates in the program, we'd want to work with us for 2 or 3 years. One of the problems that we have is, we can't stop another employer from saying, okay, we'll pay that clawback for you. But we do want to have something that we can look at and say, I'm having to make these payments. Now DPA is helping me make those payments. I like DPA. I want to stay there. That's what we're trying to come up with. And you'll see that proposal pre-session.
I look forward to seeing that. What is the average contract amount for a private attorney? I know you had mentioned that as being an issue sometimes with your attorneys who say, I'll just go out into private practice and continue to do this work without having a 300 plus caseload. Do you have a number on that?
Yeah, we have. So there are 2 types of contracts we enter into: conflict contracts, which are basically a per case contract, and then we have what we call court plans, which is we don't have somebody to cover an entire docket, and so we contract with an attorney to cover a docket. The conflict contracts, the standard contract would be $5,000, and we have a schedule by which, depending on how serious the crime is, how much of that $5,000 it eats up. So if you take a class, I think B felony, maybe $800 towards that $5,000 contract, whereas a class D would be, I think, $500. So any of the lawyers here, if you've taken a class B for $800, that's very low, but still more than once you aggregate it, that's more than we're paying our attorneys. So it's certainly not that the private attorneys are getting rich off of us, but they are getting more than we're paying our attorneys. But that's the standard contract. And so once you exhaust that $5,000, we enter into another $5,000 contract and keep going like that for conflicts. And then for the court plans, it varies on whether this is one of those all-day dockets or whether this is just a morning. The standard one that I see tends to be about $4,000 a month to handle a specific day and docket. So if you handle Tuesday district court for all the Tuesdays of the month, that would be about $4,000 for the month.
What is the average, I guess, tenure of a public defender? Do you know that as well? Is there a number that we can? And you don't have to answer that today, but I was just wondering. I think some of the turnover and so forth. What the average length of time is that someone stays.
I had run the numbers prior to our last budget presentation, and at that time it had dropped from, it had been at one time 8 years, it had dropped to 6, and then it was under 5, I think, at the last time we did the presentation. And keep in mind that we've still got some tier 1 people around like me and Scott, and so we've got some 20s and 25s figured into that. If you only look at people we've hired within, if we just say tier 3, if we've only looked at tier 3, it's frighteningly low, I think. I think it's probably 3 years. And the reason that's frightening is we still have murder cases and we still have complex rape cases and things that come in, and somebody with 2 years of experience just can't handle those cases. So we have, once all the tier 1 people retire, we're going to have a problem with having enough attorneys that have the experience to handle those really complex cases.
Well, thank you. And I'm going to stop eating up the time. Representative Bratcher. You're recognized.
Just one comment and two short questions, Mr. Chairman.
Please.
Sir, your scorecard's going to get a whole lot more lopsided if I have anything to say about it. Because 5 years ago, I was ready to get on board with criminal reform. But, man, I don't know if it was COVID or what happened. Maybe it was the governor releasing all these criminals. But crime in my district is bad. And we're sick of it. And we want your clients, if they get a plea bargain or if they get acquitted, that's great. But if they get a plea bargain or convicted, please tell them to set their life on a right path so they don't keep repeating this stuff.
That's our goal as well.
Yeah, I hope so, because we're about had it with crime in Louisville. The two questions, sir. One, now that was my opinion. Now your opinion was that the virtual operations, you don't like them. Is that just your opinion, or are you carrying the weight of your organization with that? Was that in your legislative priorities? That you don't want the, what was it, the virtual...
I don't want incarcerated clients to be required to attend virtually. I think we should go back to the way it's been for all of history until 2020.
That's your opinion. Is there any reason that's, I mean, is that just your personal opinion? Or is there something that you're saying that it's unconstitutional, or it's, what is your backing for that?
So I appreciate the question. So I'm the commissioner of DPA, so my opinion is the DPA position. I am stating that our position as an agency is that virtual court.
But there's no laws being broke, is what you're saying.
Oh, no.
It's just your opinion.
No,
you think that.
But I do appreciate the question about constitutionality. We have not, as of yet, we have been cooperating through COVID. We cooperated for health reasons to make sure everybody was safe. But there are legal challenges we could make that we have not made yet, as far as a right to participate meaningfully in the court system. When it comes, and that's going to go to the complexity of the hearing, because every defendant, all of us have a right to be present for court, and so it's a question of is attending virtually present for court, and when courts get into holding.
So this is a question that's not been answered by the courts.
As far as whether it's legal, has not been
That's all
answered.
I really wanted to know.
Yeah. Okay.
The second one is: do you recruit in Kentucky? Because some of the rural counties are saying that you're making bad fits for folks that you guys put out there, public defenders. In some rural areas, they're not good fits. Do you recruit in Kentucky before you recruit elsewhere, or is there any kind of priority on Kentucky lawyers?
It's a good question, Representative Bratcher, and I appreciate it. I had a slide yesterday that showed 56% of our lawyers are from the 3 Kentucky law schools. 44% are from outside Kentucky. Our primary recruiting is in state, simply because it's easy. We have clinics, Kentucky Innocence Project, and criminal defense clinics at all 3 law schools. We have summer internships that are primarily filled with Kentucky law students. The fact is, the 3 Kentucky law schools don't produce enough graduates who are interested in public defender work to fill our positions. And with the level of turnover we have to recruit nationally. So we do recruit nationally, and we do the best we can to fit. But right now we've got 30 vacancies we simply can't fill. So trying to find the perfect fit is not a luxury we have right now. If I've got a body that's willing to work in a state, in a county, and that person's qualified and has a license, right now I've got to hope they fit. But if they don't, those clients still need a lawyer. So we do the best we can. And if a perfect fit is something I certainly hope happens, but I don't have the luxury of being picky right now.
Thank you.
Unfortunately.
Representative Flannery.
Thank you. Question I should have asked yesterday, but so I'll ask it today. The $435 per case, what goes into determining that? Is that based upon the entirety of all staff or just attorney staff? If you could expand on what all goes into that. Is that broken down? Does that include all sorts of cases, felonies, misdemeanors, any sort of contempt or family court representation on status offenders or any juvenile?
Yeah. So it's cost per case. So the second part of your question goes to the case part, and that's the easy one. That includes all cases in the trial division, not post-trial, not appeals, not post-conviction. In the trial division, all cases, so everything you mentioned would be included in the case part. As far as the cost part, that's the cost of the trial division, not the entire agency. So it's the cost of all our rents, all our personnel, yes, attorney and non-attorney, all employees who are within our trial division, and all costs of our trial division offices. So excluded would be post-trial protection and advocacy and our operations, which is our central office expenses. So that's how we get it. Top of the fractions, all trial division expenses. Bottom of the fractions, all trial division cases.
So I'm assuming that would include any benefit to your attorney staff, such as maybe health plan, retirement, any of those factors would be included into that number.
The cost of that is included. We don't do any, tangential benefit, but the costs of retirement, the costs of health care are included, yes.
All right. Thank you, sir.
Rep. Moser.
Thank you, Mr. Chair. Thank you for your presentation. Always interesting to hear from you. And I don't want to belabor the point on virtual hearings, but we're hearing that it's problematic, that for our public defenders to have to travel all day to represent someone, I guess in underserved area of some sort. And I know that there are all kinds of variables, in terms of the complexity of cases and we have this diminishing pool of potential lawyers, but help me understand the placement of the public defenders. It sounds like you're trying to place folks in underserved areas, and I guess my question is, when we look at kind of increasing funding and maybe looking at, I don't know if it's loan forgiveness programs or what we're really talking about, but in the healthcare system, when we're looking for improving healthcare workers in an underserved area, we contractually bind individuals to work in those areas. So it sounds like we, just don't have the individuals in these underserved areas. Are they bound to work in these areas once they receive the benefit of a loan forgiveness from DPA?
So I would say, you've used the phrase underserved areas. One of the strange things, and this is a longer conversation that I would welcome with you, is that what you might think is an underserved area is not always underserved. So Pikeville, Prestonsburg, those offices, there have been times, and now maybe one of those times, when we haven't had staffing challenges at those places. But yet in Louisville, the Louisville office has 30 vacancies, and we have 5 vacancies in Lexington. And E-Town, which should be a prime location, has been at half staff for 3 years now. So our underserved locations are actually episodic. It has nothing to do with geography.
Yeah, if possible. Okay.
Yes.
All right. Thanks.
Thank you. We have 2 more members who have questions, and then we're going to go to our third item on the agenda, Senator Turner.
Thank you, Mr. Chairman. Couple of questions. The lawyer, I just sat here and figured it out. You've got $156,000 you would be paying a minimum of just lawyers that would be in Louisville. Have you all done any analysis, even in the rural area, to determine, like in my counties, that if you hired one lawyer there, by the time you pay them their retirement, their secretary expenses and all that, have you tried to figure out an analysis how much the private lawyers, I'm getting complaints from the private bar, that you could pay the private bar, because I would assume it'd probably be $80,000 for a lawyer, a secretary, retirements for both of them, insurance for both of them, that the private bar could be paid during a year, just 1 year, $80,000 to handle cases for you. See, just in that, taking one county, that you wouldn't, that would be no liability to you for the future. Have you ever done any analysis to what that cost analysis would do to help you?
Well, we do that some, Senator. We, as I said, we have court plans, and we have some counties that we're contracting with private attorneys. So we do that some. Our belief is the most efficient system is a full-time public defender system. We had private attorney contracts, 40 years ago. That was the system, and you were practicing then. You remember that. There are benefits, and certainly benefits if the lawyer's good. Not all lawyers were equally set. And so the benefit of a full-time public defender system is the accountability, the oversight, and the consistency of it. But you're absolutely right. When our Harlan office is down 2-3 lawyers, we need some private attorneys to help us out, and the efficiencies are there. The cost of the efficiencies is everything else I mentioned.
I would request that you try to do the numbers of the cases in Harlan, the lawyers, try to do some analysis in Harlan, and get that back to me. Maybe Bell also, because those are two primary counties of mine. And then I've got another thing. In some counties, you do have where the judges require all that plea guilty in felony cases, do they not, by Zoom?
Yes,
by the virtual.
Yes, there are many judges that are doing all pretrial proceedings virtually, including guilty pleas.
And I've been sitting in a courtroom, not in my county, another courtroom where a felony guy pleading to a felony and wanted to ask his lawyer something, but you've got him sitting there with some bailiff in a jail, and the judge, and them want to get. And I do believe that's very unconstitutional for that aspect. I would agree that for motions, similar things, and would be agreeable to draft a bill that would require that, because I do believe I've seen too much of it. I understand it during the COVID. I was a participant in it and still am. I'm still practicing. I've been doing it 43 plus years. When the system first created in 78, I was there. So I do believe that you need to do those two analyses, because you're going to have this long-term debt of retirement and everything's going to accumulate. This body's going to have to provide.
Yeah.
And the local lawyer is going to pay his own insurance, his own secretary, and all that. So there's a multiple savings there. And I wish you'd do some analysis, especially in small county. I can't take care of Louisville, but in the rural area, I've been approached by numbers of lawyers saying, please try to get that done, because we would take the cases at much lesser, because they need the business, public needs the service, and they'll agree to do the service. So please look at that. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator. Representative Dietz.
Thank you, Mr. Chair. I'm speaking as an attorney that has her own practice, small in Northern Kentucky, but I'm also the mother of a law student that just completed his first year and is going. So the big firms start recruiting immediately. I know what those salaries are. I know what I'm able to pay. I know what our Commonwealth attorney is also able to pay, which is very similar to what you've testified to today. It's hard to compete with Cincinnati. The hourly rates are higher over there. I can't pay a young attorney what a Cincinnati firm can pay. So I'll start with, nobody ever wants to pay their lawyer. And I think it's placing a value on the service that attorneys offer, whether it's the Commonwealth attorney, whether it's the public defender, or private attorneys. It's placing a value on it. And so it's more of a statement that we need to put more value on the services that attorneys are offering. And we're the butt of a lot of jokes, but at the end of the day, we provide a service that should be fairly compensated. So all around, I think that the salaries feel very low, and I know that we cannot fill our positions in Northern Kentucky because of the competition that we have. I think my second comment is on virtual hearings. As a domestic attorney, we still do a lot of Zoom. I find it very difficult to communicate with clients. During COVID, I had a 6-day custody trial. Very difficult to text. I don't necessarily want everybody to have my cell phone number. No. If you have something private you want to say, sometimes just putting your hand on somebody's lap to tell them to be quiet is a whole lot better than trying to text them to stop talking. Right. So I agree. I mean, on certain things for sure, arraignments and those things, but I agree that being back in the courtroom, I think, is important. So thank you.
Thank you, Representative.
Thank you, Representative Flannery. The last comment, very quickly.
One thing I've noticed in practicing law, there seems to be a very big disparity in how sometimes I think particular district court judges may appoint the public defender on a lot of cases, maybe the ones they shouldn't. What could we do to maybe prevent the accused, those persons who aren't indigent or who could pay something to, I guess, kind of curb that practice of just appointing the DPA to just about all the defendants? Some judges are maybe good at that, others aren't.
This has been a conversation for many years, Representative Flannery. You're exactly right. There are courtrooms where DPA essentially is appointed to every case, and it happens so early and with such little analysis that the the person before the court never even thinks about hiring a private attorney because it's just express trained at EPA. We are not fans of that any more than the private bar are, because that overloads our lawyers that could be spending their time on other things. But it happens from place to place, and so as far as a legislative fix, it's tough. The language is good in Chapter 31 for the review that judges are supposed to do. There are costs they can assess if someone is kind of indigent, that they can't afford you, but they have a little bit of money. There are fees that can be assessed. So I think it's just something that needs to be changed from court to court. We try to address it, but it's tough for us because by the time we can address it, we've actually got a client. And so we're actually saying, Judge, I don't want this client. And that's hard to do. So I would say talk to your local judges in your area, because some of you probably have judges in your area that are that. But Mr. Chairman, this is actually a good thing to end on, because it goes to the first thing I said, which is public defenders are essential to the system. And in many courtrooms, we're just part of the efficiency, and it's more efficient to appoint us than to say, come back next week with a lawyer. That's not the way it's designed. And if we can address this issue, that would give us more time to do other things. But we're happy to serve as best we can. And that's the other thing here, is we want to serve the Commonwealth. We want to serve you all and the public. And so the better we can do it, the better we're able to serve. And if we can limit our cases in that way, that would help us.
Thank you, gentlemen, for a nice discussion this morning, and appreciate your presentation. We will move to our last item, which is privacy protection. Representative Hodgson, Representative Blanton, Representative Grossberg, if you would come to the table and introduce yourselves for the record, and then you can proceed. Thank you.
All right, thank you. Thank you, Mr. Chairman. John Hodgson, State Rep 36. My colleagues, Representative Blanton and Grossberg. We're here to talk about electronic privacy from electronic surveillance. Sorry, I'll get this a little closer. I may be too tall for the microphone. Privacy from electronic surveillance is a rapidly evolving issue, so much so that it's challenging for legislatures to stay ahead of it. This bill covers 4 types of emerging technology, and we may well add a couple more before the session starts, but we want to start the discussion with the Interim Joint Committee this summer. This bill is a bipartisan team effort. It's widely supported by the public. Nobody really wants the government or their neighbors spying on them, stealing their data, or tracking them. And that's the genesis of this bill. It's been provided to you for your review of the full text of the bill, as well as a review of the public. We want to begin digesting the information and providing feedback so we can avoid unintended negative consequences of the language. There's no secret provisions in here, no pride of authorship. We as a group of co-sponsors just want to see the legislation covering these topics enacted to protect our citizens. Most of the bill concepts were gleaned from statutes that are in place in other states and tailored to fit within the KRS. The co-sponsors will now briefly explain the 4 main provisions of the bill. The first one you've seen before. The late Lamin Swan introduced House Bill 438 last year. There was a similar bill in the Senate that limited the retention and sale of license plate reader data. The primary provision was to limit that retention to 90 days with certain law enforcement exceptions, and to limit the selling of that information to private entities. There are a number of private entities who would love to buy license plate location data from us. So that's the first provision of the bill. The text is almost exactly what it was last year when this committee reviewed it. And now we'll move to Representative Blanton for the section on drones.
Thank you, Representative John Blanton, 92nd District. So very basically, this drone privacy legislation is modeled after what Florida has recently enacted. We've began to see an increase in people, you can buy drones now in the toy section, right? And they're flying over people's private properties, and they're taking videos, pictures, and different things. And also, sometimes that includes children out in the swimming pools and different things. And, normally they wouldn't be used for improper purposes, but sometimes they are. And so what this does would make it illegal with the exceptions for certain types of law enforcement use, for someone to fly a drone and take images over someone's private property that they couldn't see from standing in a public place. Obviously, if you can stand in a public place and see, that wouldn't apply, but to prevent them from flying these unmanned drones over top of a person's private property to protect their privacy rights. I mean, the last thing we want is be out with our kids or grandkids in the backyard in a swimming pool and someone fly over our home with a drone, because right now there's nothing that says they can't, and take imagery and then put it on the internet and use it for improper purposes. So that's what this bill does.
Thank you. I'm Representative Daniel Grossberg from the 30th District in Louisville. If it pleases everyone, I'm actually going to go out of sequence because my speech is written as such and begin with the AI speech. In April of 2018, a journalist became the target of an online harassment campaign. Much to her horror, sexually explicit videos of her were being posted and shared all across the internet, eventually leading to stress-related health conditions and a withdrawal from public life. The issue here was that she was not really in any of the videos. Instead, her likeness was portrayed using a deep fake. A deep fake is a fabricated video or audio clip made with machine learning to imitate a real person. Since the term was coined in 2017, this emergent technology has advanced rapidly. Anyone with a cheap program can create a deep fake visually indistinguishable from reality with less than a minute of audio and a handful of pictures. Both the Department of Homeland Security and the FBI have released reports with dire warnings of how this new technology may be used. Fraudsters can now mimic reality at a level once thought impossible. Online predators can lure children with realistic young avatars. Deepfake pornography can be used to harass women who post on social media. In fact, according to a deepfake detection agency, Sensity AI, up to 95% of deepfake videos posted online are non-consensual pornography, virtually all targeting women. But deepfakes can also be used to harm business, criminal enterprises, criminal accusations, and have political implications. As the 2024 primaries draw closer, that perception may change, possibly requiring an emergency clause for any relevant legislation. Realistic misinformation campaigns can be produced for dirt cheap against any incumbent at any level. Using only footage on KET live streams and photographs from the legislative website, any representative or senator can be a puppet on strings for bad actors. Even when the fakes can be spotted, their proliferation threatens the validity of all forms of digital communication. If anything you say could be artificially generated, why believe anything? Can a jury of your peers spot the difference between real and deepfake security camera footage? Can scientific data be taken for granted anymore? What about journalism? What about history? The culmination of the information age has created the greatest tool of deception. So far, 2 other states, California and Virginia, have made the abuse of this technology a crime. Kentucky should be the next to join them in protecting not just the privacy and dignity of our citizens, but the truth and democracy as well. And finally, as for microchipping, the relationship between man and machine has gotten closer and closer as we march further into the century. Today, we are content to carry supercomputers in our pockets. Many of us on our wrists track our location, our vitals, and our habits. Tomorrow, it might be augmented or even virtual reality over top our eyes. But some have already taken the next step with injected microchips. Implants no larger than a grain of rice are inserted in the hand, containing user data or allowing users to unlock doors and use certain equipment. Still in its infancy, this technology could expand to uses previously thought impossible. Like any new technology, could also be used for the unthinkable. Trials in Sweden have been around 3,000 individuals voluntarily chipping themselves so they could use their hands in virtual wallets, similar to Apple Pay. Across the world, smaller tech companies have a trial running similar programs with limited success. But one can imagine the widespread push for these implants once the value of the data collected by them outweighs the cost of implementation. Many employers today require phone applications to manage schedules and time cards. Implanted microchips could merely mainstream the process. The fact that microchipping has yet to gain traction gives our legislature a unique opportunity. Unlike artificial intelligence, representatives and senators can take the time to fully understand the technology and place in their communities before the issue spreads like wildfire. First and foremost, with an advancement that has been so invasive to the body itself, we must take this opportunity to protect those that do not want microchips inserted in them for identification purposes. These concerns are not only understandable, but essential to maintaining the independence of the individual. 11 other states across the country have seized this moment, protecting everyday men and women from potentially being coerced or even required to inject themselves with chips. As a state that has maintained a frontier spirit for 231 years, we should be swift in the adoption of legislation to prevent corporate mandates of invasive procedures before it's too late. Thank you.
Thank you very much, Representative Bratcher.
Well, I really like this bill, but it's got several legs, right? Several components.
Yes, four components.
And that would be AI.
Yeah, the deep fakes, drones, license plate reader data, and microchips. The four legs.
So the license plate portion, I don't know about that one. So can you explain what's going on with that?
Okay, so there are flock cameras all over the place in Kentucky that are capturing license plate data, and it's very useful for law enforcement if they have a carjacking, car theft, fleeing suspects to find out where those people are. But there are lots of people who would like to have that license plate data, private users. Right now, I don't believe that there's a law that prevents the government entities that own those flock cameras from selling that license plate reader, let's say to a car repo company, but marketing people as well. And that data on your license plate is essentially giving away your position, so it limits the retention of that to 90 days unless it's being used for some lengthier law enforcement purpose. Just, endless data about where you are and what you're doing being kept forever is generally not a good idea.
Well, that sounds reasonable, and I'm glad it's a bipartisan. I hope it is a bipartisan. It could fly through this area. I'm sure there's some changes coming, but I like it, so thank you.
Thank you, Representative. I guess to Representative Grossberg, the part of the bill that you were discussing, the bill would prevent corporate mandated microchipping. Does it also contemplate restrictions on any government mandates that might be put out there at all?
It does not, Mr. Chairman, precisely because I have the expectation that at some point the United States military is going to mandate it for all of our enlisted and commissioned personnel, and I don't think that we have the authority to refuse it here. Others may disagree with me, but I think that will be disputed and litigated at the federal level. But if you wanted to include a provision that Kentucky state employees could not be mandated, I would be amenable, and I presume my colleagues would be amenable to that as well. But I respectfully don't think we have the authority to tell the federal government that they can't do it.
Sure. Do you have any other comments or discussion this morning? Looks like we don't. Do you? Any closing comments?
Just a closing thought. We are looking at a couple of other things. I've recently been to some legislative conferences talking about AI. Frankly, we're not quite sure what to do about it, but it's something of an emerging threat in general with work products. And also, everybody's familiar with the trackers you can put on a vehicle. Well, they now have trackers that you can drop into somebody's coat pocket and monitor their location. So we're looking at possibly adding something along those lines. We passed a bill last year to say you can't track somebody's vehicle, so this would just be adding a clause saying, you can't put a tracker on their person either. And that technology is also getting as small as a grain of rice. It's kind of scary.
Well, thank you for each of you for your presentation.
If I may, Mr. Chairman,
Yes,
I just want to acknowledge my college intern from the last session, John Campbell. John, would you stand real quickly? He helped me tremendously on my portion. I wish I could give him more credit than that, but I can't speak to the other portions, but I just wanted to acknowledge them.
Welcome. Representative Kulkarni has
Thank you, Mr. Chair. I'd just like to recognize my guest, Jessica Mukhopadhyay. who is visiting us here from Lexington. She is going to be a senior in high school, very interested in our government and being engaged civically. So we're very happy to see her. Thank you.
Great. And I want to recognize Robert Wright, who is a new staff member on our committee. And thank you for being here, Robert. And we look forward to your work. And thank you, gentlemen, for your presentation. This is very timely and very informative, I think. So do we have a meeting date? What's our next meeting date?
September, I don't remember.
Okay.
Sorry.
That's okay. Well, we will be meeting again in September. We don't have the exact date, but I think it's already been set and on the calendar. Is there a motion to adjourn? We stand adjourned.